case briefs, and so much more. LSData's got what you're looking for.
In the 2001 case of North American Specialty Insurance v. Lapalme, the United States Court of Appeals for the First Circuit addressed the issue of whether accountants can be held accountable for errors in financial statements and audit reports when dealing with third parties. The case focused on the idea that accountants can only be held responsible to certain third parties if they know that someone will rely on their work. The lawsuit was initiated by North American Specialty Insurance Company, NASI, a third party which sued Dias and Lapalme, D&L accounting firm, and one of its principals, David Lapalme, for negligence in a financial statement prepared for their client, Canty Roofing and Sheet Metal Inc., CRS. NASI entered into a bonding relationship with CRS and claimed that the financial statement contained negligent misrepresentations. The lower court granted summary judgment in favor of the defendants, ruling that they were not liable to the plaintiff. On appeal, the appellate court also found that the defendants were not liable to the plaintiff, but their interpretation of the governing law differed from the lower court. The court held that the plaintiff failed to provide sufficient evidence for all 6 elements required to establish liability, and thus the defendants were not accountable for the mistakes. The case clarified that accountants can only be held liable to non-contractual third parties if they have actual knowledge of the limited group of potential third parties that will rely on their work product and the specific financial transaction that the information is intended to influence. Since the plaintiff failed to provide sufficient evidence in this regard, the summary judgment in favor of the defendants was upheld.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.